Good morning, all. I hope you're doing well. My name is Miller Whitehouse-Levine from the DeFi Education Fund. My update today is that on Monday, we and a co-plaintiff sued the SEC over two issues. The first, our co-plaintiff is a small bag manufacturer, like duffel bags, based in the US, and the founder is really into digital assets. The business, though, is generally unrelated, totally unrelated to digital assets, except for the fact that they created Beba tokens, the name of the company is Beba, and airdropped them to potential customers, gave them away for free to potential customers on Base, which is an Ethereum L2. The Beba believes that the SEC will incorrectly view that airdrop and future airdrops to potential customers, think of it as almost for marketing purposes, to be securities issuances, and at the same time believes the SEC is incorrect on the law with that conclusion. So they are preemptively suing the SEC, alleging that they have a credible fear of enforcement because the SEC has brought enforcement actions in similar fact patterns, and is asking the court for a declaration that their airdrop and planned airdrops of their Beba tokens are not investment contracts or securities transactions. Separately, we jointly bring an APA claim alleging that the SEC's adoption of a nearly all digital assets and transactions involving digital assets policy was invalidly adopted because they did not go through notice and comment when they came up with that novel premise. So the idea here, which is a bit unique, is that we believe the SEC, I don't know exactly when, but after Chair Gensler entered office, ended its policymaking deliberation process and landed on this fifth prong of Howey that is a digital asset involved, and if so, an investment contract is likely present. And we are asking the court to find the SEC must go through notice and comment if they hope to adopt a rule to that end, which is not to say that their adoption of such a rule would stand judicial muster from a statutory authority perspective. So that is the thrust of our case. You can kind of think about the two claims being separate but related, in that the enforcement and regulation by enforcement in the crypto space, and as could be applied to Beba, is an implementation or an expression of the SEC's policy that they adopted without going through notice and comment. I am happy to answer any questions.
Anything else? Okay.
Thank you all.
Thank you so much, Miller.